Yes.
Adjournment request, if any, from item number 1 to 3. From item number 4 to 14, adjournment request.
This, my lord, with respect to item number 6, my lord, an adjournment slip had been circulated yesterday, my lord.
Adjournment slip has been circulated sometime.
Highly obliged, my lord.
May I please, Lord, I beg to mention item number 5, my lord.
5.
My lord, I have taken the consent of the other side. I am for the private respondent.
You are for the private respondent. Which respondent? Respond number?
5,
Respondent number.
5, my lord.
In item number 5, you are appearing for respondent number 5.
Yes.
1.C is actually on behalf of our children.
I think you're not correct. Either you're not understanding what I am talking.
Yes.
Anyway, as prayed for on behalf of one of the private respondents, after having taken consent from the counsel for the appellant and other respondents, re-notify on sometimes late February or early March. All right.
10th March.
May I please, your lordship? With the consent of the other side, I beg to mention item number 8 and 9, lordship. Lordship, on behalf of Mr. Jaya Borhoya, he is on medical urgency, lordship, on leave. Lordship, immediate after Bihu vacation, lordship, fix a date.
And that we'll see as prayed for on behalf of the appellant. As prayed for on behalf of the appellant in both the cases. Re-notify.
16th February.
I wish to mention item number 10, your my lord. Lordship.
10.
Item number 10, your lordship.
Yes.
Due to medical urgency of my senior, I am appealing for respondent.
Similar as
Same.
ever. be.
Ground.
Lordship, I am for the Appellant Union of India. Lordship, he has contem is also pending. Lordship, so if date after Bihu, Lordship.
No, you are for.
Union.
You are for.
I am for the
respondent.
appellant.
Appeal. I am for the respondent, your lord.
Why don't you stand at the correct place? So you're for Union of India.
Lordship,
All right. You want it when?
after Bihu, a fixed date immediately.
All right.
Contem is pending.
All right. As prayed for on behalf of the parties, re-notify on sometimes in February first week.
Obliged,
All
Lord.
right. All right.
5-2.
Lordship, with the consent of the other side, I beg to mention item number 18. We need some time to file our rejoinder.
18, you have already circulated the adjournment slip.
Yes.
Yes.
All right.
Please, lordship, I beg to mention item for listing of a matter.
Item for
No,
Listening.
I will listing of a matter. First,
Sometimes, sir.
Friday, matter.
Friday.
Friday, my lord.
I don't think so. It
But
goes
very,
after. It goes after view. Immediately after view. But what is the urgency?
It's a reinstatement matter order.
It
No,
is a-
I'm against the order of the tribunal.
Reinstatement matter.
I'm against the order of tribunal.
No. Last week of February.
34th February.
Yes.
May it please your lordship. My lord, I beg to mention listing of a writ appeal today, my lord. My lord, the government, I have challenged the government tender, and yesterday the honorable single bench has not granted the interim relief in the stay on the government tender, my lord, and the tender will commence today at 3:30 p.m., my lord.
So what was the ground?
My
Why?
lord,
What have you challenged?
My lord, I'm a MSc registered firm and I am seeking for a EMD exemption as per MSME policy and as per the bid document and the terms and conditions
That's
of
right. Did you ask for it? Is there any provision in the tender paper for that
Yes, ma'am.
exemption?
Yes, my lord, that is
And
it.
you prayed for it and it was rejected.
Yes, my lord.
It rejected with a reason or no reason?
It will be considered at a later stage and I was directed to submit 50%. My lord, if it can be taken up, some consideration may
no,
be
no, no.
granted in this matter.
It can be taken up tomorrow, not today. Tomorrow it will become infractious if the
Infractious, my lord, because the bidding will commence today. If it can be just given a consideration.
No, not
2 p.m.
no. Today we have a reference and all that. No, sorry. If you want, we can put it tomorrow or immediately after view. Something happens if it is not taken up today. When do you want it?
My lord, if it can be taken up tomorrow so that no vesting order is passed in this respect. I have made those prayers, my lord. If it can be taken up tomorrow, my lord.
All right, tomorrow.
I'm deeply obliged, my lord.
May I please, your lordship, my lord, I beg to mention item number 2324, lordship. Here, my lord, in item number 23, lordship, I have filed one affidavit in reply, lordship, to the affidavit in opposition filed by the respondent number 5, lordship. So kindly, my lord, this matter will be taken up on 26th or 27th of January, lordship, along with the affidavit, lord, which was filed by the petitioner, lord.
You are appearing for the petitioner.
Petitioner, lord.
Those auction of Erica nuts
Erica, lord.
as prayed for on behalf of the petitioner. Petitioner, let this matter come up for consideration on after view. January only.
28th January.
20. Highly obliged.
May I
Yes.
please, your lordship? Lordship, with the consent of the other side, I beg to mention item number 21, lordship. Lordship, kindly adjourn the matter for today, lordship.
This is that ferry settlement cancellation.
Lordship,
What do you want?
lordship, kindly adjourn the matter for today. My senior is out of station, lordship.
As prayed for on behalf of the appellant. You're for the appellant.
Lordship,
As prayed for on behalf of the appellant, re-notify. February.
16 February.
My lord, in item number 30, supply list, I have filed a IA today.
Yes.
So my lord, this, the IA may be called today, lordship, matter may be taken at 2 p.m. Obliged.
Not 2 p.m. anytime that we are through. File will be here anytime.
Obliged.
Hello.
Lordship, I beg to mention item number 31. Mr. UK Goswami, CGC is dealing with the matter, Lordship. There is bereavement in his family.
No, otherwise also this this matter about second pension is pending. before the
Yes,
court.
yes, he
Has
has
it been
informed.
decided?
He has informed me that it is, one matter has been, notice has been issued on 5th of this month.
No, let this matter as prayed for on behalf of the Union of India.
Lordship,
Let this matter come up for consideration on. We keep it in March,
as your Lordship pleases, Lordship.
first week of March.
5-3.
May I please, your Lordship? Lordship, I have to mention for listing a readable along with IA, Lordship. After vacation, Lordship.
But what is this matter?
Matters related to Lordship, tender matter, Lordship.
Tender is a big matter, tender cancellation,
Also-
tender you have now said. I mean, what is the urgency? Why do you want to mention?
There is already delay.
Come prepared after Bihu, we will hear and we will fix it. Right? If you ask for an early listing, you must tell us what is the matter.
Any other request?
Chalo.
Daily list for orders item 1.
Coming for the first time.
Praise your Lordship. Lordship, we have filed an additional affidavit today itself. So kindly, can the matter be fixed after view vacation?
As prayed for on behalf of the appellant applicant. Let this matter come up for consideration on Bihu.
4th of February. 4-2. Item 2.
Wait, please, Lord.
Hmm.
In item 2, my lord, I forgot to take steps, my lord. So may I pray for some time so that I can.
Notice has been issued, but no steps. When I step, you will notice that one.
It's my fault, my lord.
Have you?
It's my fault, my lord. I forgot.
Mr. Khatniar, learned advocate for the applicant submits that because of some miscommunication, steps could not be taken for each one's notice to the respondents. Let notice be issued to the respondents on requisites being filed by the applicant within a period of 1 week positively. Both modes returnable in March.
Obliged.
Do we make this order peremptory?
Sorry.
Do we make this order peremptory?
Oh.
If you don't file it within a week, then it is dismissed without further reference to the bench.
I'll do today itself, my lord. I'll do it, my lord.
9th March. Item 3.
Application for condonation of delay.
पूरा detail लिखना. Notice to R1.
Right.
Both
Okay.
modes. Returnable, date declare March.
9-3. Supplementary list, item 27 for order.
Nobody appears on behalf of the parties. List this matter for consideration under the appropriate heading on.
Item number 27, I am appearing for that. But this is,
There is no service report of newly substituted respondent.
my lord, steps has been taken, my lord, lordship.
That's right, you have taken steps,
My,
but there is a service report regarding service report with respect to Salico. The report regarding service of notice on the newly added respondent is awaited. So let this matter come up for consideration on February first week.
obliged.
6 February. Item 28,
Legal lordships.
Response number 11 has not served its
Illegal
yes.
lordships. Others appear, one appear lordships.
That
But nobody submitted any objection also. In the respect of I live and await yet.
report. Respondent number 11 file.
No,
That is what I allowed it.
14 days.
There is no report regarding service of notice on respondent number 11. Awaiting the service of notice on respondent number 11, the matter is adjourned to February last week.
25th February, 25 cube.
Oh.
Item 29,
Phone number 5 has not been.
My lord, there is an IA for continuation of 91 days of delay, my lord. The service report indicates that neither AD card nor unserved notices have arrived. Now, the problem here, my
You're appearing for whom?
I am appearing for the private respondent number 5, your
it's
lordship.
completed. then.
5 has been served then. You want to oppose?
Yes, your lordship.
Have you filed your response?
Some time may be granted.
But why? On our asking? Otherwise, you can make an oral opposition. 91 days, we are inclined to condone the delay.
Lordship, the documents, NH,
Only answering respondent would be respondent number 5.
Yes, my lord. In fact, the respondent number 5 was the writ petitioner, and I was the successful bidder, my lord. The issue here that has arisen is that, my lord,
Let him respond.
my
One
lord,
week.
my lord, there's a liberty granted to the excise department to reinitiate the process of tender. If that happens, my lord, this appeal, in my humble submission, my lord, would be an academic exercise, my lord. And we have good grounds.
But what do we do?
My lord,
He
a
is
short
coming-
date may be granted, my lord.
That's
if-
what we are saying, 1 week.
1 week, my lord.
At the request of the land
After
council,
view, your lordship,
at the request of, it has to go 1 week. If we say it has to go after you, at the request of land council, who has entered appearance on behalf of respondent number 5, let this matter come up for consideration on immediately after the opening, by which time the response affidavit, the objection affidavit by respondent number 5 shall be positively filed.
21-1,
I'm grateful, my lord. I'm grateful.
21-1. Take time. Daily list for admission, item 4.
Lordship, last occasion, Lordship directed me to place the copy of the writ appeal filed by Ministry of Defence. Lordship,
This appeal is by Ministry of Home.
yes, Lordship. Lordship, the Ministry of Defence filed the writ appeal stating that they are not liable to pay compensation.
That's true, but then the tenor of the order dated 15/5/2024 tells us that the court was not convinced of any argument on merit. So it was just a change. You want something else, then you need to file an order. You need to challenge it before the Supreme Court.
Lordship, that is correct, but here, Lordship, the Ministry of Defence filed the writ appeal only on the ground that they are not necessary party, they are not liable to pay.
That's all right. So, but the merits went off, no?
Lordship,
Let us see the memo of appeal.
Lordship, memo of appeal, which Lordship, Ministry of Home Ministry or Lordship?
Why Home Ministry is here.
Yes, Lordship.
I'm asking about the Defence Ministry, the appeal
Lordship,
file preferred by.
That I've given Lordship the copy of the appeal.
Look at this, the challenge, there was a challenge.
Lordship, their main contention is that they file affidavit and their contention was not considered and they are not liable to make payment because land was the alleged land was in occupation of the Ministry of Home. That is their contention. But if this is a order passed by the London Division Bench.
And this is not on merit. All right, we'll hear you. This is not on merits.
Lordship.
So we'll hear you. Yes.
Lordship, our main contention is that the London single judge, the land was not in occupation of the armed forces at the relevant time. And Lordship,
How do you say that?
because Lordship,
The joint verification team had verified, checked the documents,
Lordship, have come
and
to
had found that there were trenches dug up on the land of the private respondents.
Lordship, they failed to prove. Lordship, page 90 may kindly be placed there of my memo of appeal.
I don't think.
Their claim earlier it was rejected
I
by the
don't-
Ministry of Home, Lordship.
No, you are deliberately avoiding making payments. Now, what
No.
evidence would they have?
Lordship, they didn't produce any evidence that the land was at the relevant time.
What was this joint verification team doing?
Lordship, that we have challenged, Lordship. Lordship, may please to see the,
A very recent judgment has been passed by the London single judge, Mr. Kal.
Lordship, may please to see page 1999, paragraph 8.
Page 99.
Lordship, paragraph 8. This is the finding of the Leonard single judge.
Read.
I have heard the submission made by the Learned Counsel for the rival parties, and I have perused the materials available on record. As may be noticed, it is the second time the petitioner are before this court. The first writ petition was disposed of with a direction to have a joint verification on the claim made by the petitioner for payment of rental compensation by constituting verification team. As directed by the verification team conducted court verification on 15/10/2014, and the report is annexed as Annexure 4 to the repetition. A perusal of the report would go to show that the joint verification team verified and checked the documents of the petitioner in presence of the member of the Vigilant Council and senior citizen of the area. The verification team noticed that there was no proper registration of individual and holdings, particularly in the remote area during the erstwhile Mizo District Council. The only document supported the claim of made by them was a village council pass issued by the village council concerned. A copy of each of the document produced were also accounted by the verification team by attaching the same to the report. The joint verification team also did not find any document being maintained showing the occupation of the land by the security forces. But however, the statement of senior citizen and member of the village council were only source available to prove the correctness of the claim made by the petitioner. Apart from the joint verification team, team found some old trenches dug of the security forces, which were still available at the various
The
locations.
reasoning is in the last part of paragraph 9.
Lordship.
That you have read all in your favor. But last 5 lines, 1, 2, 3, 4, 5, 6. The
Recording says finding.
the sentence, no. The sentence begins from the joint verification team.
The joint verification team entered the details of the land, which
No.
a
Below
remark
that.
of each
You
of
come
the
6 lines from the bottom.
paragraph 9, Lord.
Yes, sir.
Lord.
1, 2, 3, 4, 5, 6 line.
It is fact that the actual area of land.
You first count, Mr. Kal, the
Lord.
6th line from below.
of-
The
of
sentence begins from the middle,
paragraph
page 100.
Page 100. Lord. The joint verification team also undertaken the exercise of hearing the senior citizen and the village council during the joint verification, and therefore, in absence of any dispute from any quarter about the occupation of the land by the security forces, the joint verification report will have to be relied upon by the considered view of the court. As already noticed, in a case of similar nature, where landowners had claimed rental compensation, a similar direction for joint verification was made by the report of the joint verification goes to show that the team was of the view that it was not possible to prove or dispute actual occupation of the land by the security forces from the record, but fact that the land were occupied by the security forces could be made out from the testimony of the local leaders.
Now, in this situation, when you had to fight the Mizo ultras and the security forces had to take control of the land for digging trenches, for saving themselves, what evidence do you require except the the joint verification report was constituted under the orders of the court.
Yes, Lord, that is correct.
The matter had traveled to Supreme Court. Supreme Court had remanded the matter, approved of it. The constitution of the joint verification team was not questioned. Now, therefore, when you take up, you don't have any records because that was an emergency situation. Think of those days when the Mizo ultras were after the life of the Indian government. And these villages, they had village passes. They did not have even the land registered, remote villages
Yes, Lord,
in
correct.
the border area. But there are evidences of trenches dug. The villagers would not dug trenches. Of course, the evidence is very, very,
Weak.
what should I say? It is not for usual purposes. This evidence would not have convinced us. But think of 1960s and 70s. And you also, you computed the compensation amount. You forwarded it to the DZ. But then on second thought, you said, no,
No,
let
Lord,
them produce evidence.
Lord, please come to page 90, Lord. That claim was earlier rejected and the learned single judge.
No. Earlier it was never rejected. The matter was joint verification team was constituted. How do you say rejected?
Lordship, in genuine cases, government of India has made payment to the many genuine persons.
How do we know?
Lordship,
Genuine cases, how do you say this is not genuine?
no, because Lordship,
Because of the evidence being perfunctory, you can't say. I mean, you produce an evidence that you did not occupy the land.
because our contention before the learned single judge, we file affidavit that we have also annexed here. And our
You show us from the record that with respect to others, you maintained a record that you have taken their land. You don't have record for anything. It's your just sweet will. You pay to Mr. X, you don't pay to Mr. Z.
no, Lordship, that is Lordship, after the finding of the
You show us that at that time you paid something to somebody.
yes, Lordship.
Have you maintained record of that?
Yes, Lordship.
Where is that? Show us.
Today it is not.
You show us. We are not asking you to show it.
I'll call from the ministry, Lordship. I'll produce before Lordship.
As prayed for on behalf. But then you are only delaying the payment
No,
to
Lordship.
these poor villagers.
Lordship, we have made 150
And
crores
what is
to
this?
51%, Lord.
Now, otherwise also the merits, I mean, of course, in the appeal preferred by the that modification. That is a modification.
Lordship, till date, as per my information,
The difficulty is this, that the appeal on behalf of the Defense Ministry
Yes, Lord.
was accepted when the prayer was only for deletion of their names and substituting their names with the others.
Lordship,
So this could have been done only in review or perhaps in modification of the judgment.
that
Appeal could not have been filed for that. Once an appeal has been filed, it has been entertained. That means on merits, the division bench was convinced. We'll take this plea. That the division bench was convinced that the respondents require to be paid compensation.
no, that is finding of the learned
I
single
think
judge.
the better way out is to go to Supreme Court. Your department, I mean, department under the government.
Lordship, that difficulty is with me, Lordship.
You withdraw otherwise we are not interfering. We will take the view that was if the appeal has been entertained, that means it is on merits as well. Of course, the order has been passed that Mr. X is not liable to pay, Y is liable.
Yes, yes, Lordship. That is
Therefore, the issue has been decided.
no, Lordship.
You think about it, the better option for you is to challenge this judgment. That nothing was done on the merits. Nothing was done on merits. Merely there was substitution of the name of the person who was liable to pay. And therefore, when another appeal was filed, the bench took the objection that the matter has been decided. This can only go to Supreme Court.
This present appeal was filed when it was at the initial stage was filed, when it was not disposed of, as per my instruction.
Take a call. If you that on the next occasion, be ready with those documents where you have maintained the records. Number one, even if that is there, you'll have to cross this hurdle.
That Lordship, that is we have.
You have to cross this hurdle. That one appeal has been filed, dismissed with modification.
Lordship,
otherwise the other bench which undertook the appeal, which decided the appeal, They would have said that no, since you are not questioning the merits of the judgment of the single judge, you just want the name to be swapped, then go in review, or for that matter, go for modification of the judgment.
But Lordship, in paragraph 6,
Or you file a review of the division bench judgment. That you have not said anything about merits.
yes,
Please talk about merits.
it is there, Lord. That,
So withdraw this, file a review before the same bench.
Lordship, I may obtain instruction.
Take instruction.
Lordship,
Mr. Kale, after some argument, seeks. Do we indicate this?
Lordship, it is better.
In that case, it will be better for you to take instructions and let your clients know that this was a mistake committed.
Lordship, I've already intimated, I've also written a
We
letter.
have heard Mr. Kale, we have heard Mr. Kale, learned advocate for the Appellant Union of India in the Home Ministry. By the impugned judgment dated 15/11/2023, a learned single judge directed the appellant to pay to the respondents the rental for their lands, which was occupied by security forces for a reasonably long period, and also directed for payment of interest at the rate of 6% per annum till the final realization of the compensation amount. This judgment was initially challenged by Union of India in the Defense Department, which was entertained. Defense Department by WA number 6 of 2024, which was entertained by a division bench of this court. But by judgment dated 15/5/2024, the bench did not question the correctness of the judgment of the learned single judge, but only clarified that the amount of compensation payable to the respondents and that only clarified that the Appellant Union of India in its home department would be required to pay the compensation amount to the private respondents. While preferring this appeal afresh, Mr. Kale submits that the division bench in WA number 6 of 2024 did not entertain any argument with respect to the merits of the judgment impugned, but only swapped the department which was liable to pay to the respondents. The submission of Mr. Kale, is not worthy of acceptance, as if it were only to name the department responsible for making payment, no appeal would have been entertained, and the matter would have been relegated to the learned single judge for modification of the judgment. Once the appeal has been entertained, it would be deemed that all arguments against the merit of the judgment were entertained but rejected, with only the clarification that the Home Ministry would be liable to pay to the respondents the compensation for their lands to have been occupied by security forces for fighting Mizo ultras. Mr. Tyal thus seeks some more time to take clear instructions in the matter. Let this case come up for consideration on February.
Much of.
Deeply. 11-2. Item 7.
May I plead the Lord? Lord, this appeal has been filed challenging the judgment and order dated passed by the learned single judge lordship on 10/4/2024. For your lordship 10/9.
Normally, we would not have agreed with the judgment of the
Lordship.
single judge, normally because of the contractual employment.
Lordship.
But here the terms of the contractual employment itself says that everything would be governed by the disciplinary rules of the government.
Lordship. My lord, that
What-
in this Lordship, my lord, that as per
That's the only hurdle.
Lordship, my lord. Lordship, my lord,
What is it?
kindly see the Assam Service of Disciplinary Appeal Rule.
Yes. Yes.
Lordships, on in terms of the my lord, that Rule 7, Lordship, G3, Lordship, this termination has been made, Lord.
Where is it?
Lordship,
What are you trying to show?
Lordships, in our affidavit, we clearly stated, Lordships, in the paragraph.
Page.
Lord.
To formulate your argument.
Lordship,
first.
page 62, Lord. The relevant portion is, Lordship, page 64.
This is the affidavit in opposition filed before the single judge.
Lordship, Lord.
Yes, what is it?
Lordship, my lord, the paragraph number 4, the merit, Lordship. With regard to the statement made in paragraph number 7, in a writ petition, the unsigned deponent back to state that the petitioner is a contractual employee, was terminated from the post of district project officer, Hailakandi, as per terms of engagement in the contract. Then, notwithstanding
That is
anything.
saying no, that is the reasoning given by the single judge, Mr.
Lordship, my lord, that 7, my lord, that the other, my lord, that the rules is applicable for those who are, my lord, the regular employee. Man, he is a contextual employee. Lordship, in the honorable, the apex court, my lord, that one judgment has been given. Lordship, I kindly peruse this judgment, Lord.
No, as per Assam Civil Service Discipline and Appeal rules
Lordship,
or of any breach of non-performance.
Lordship.
So
Lordship,
not-
kindly see that terms and condition of the, my lord, that contract, Lord.
we said so, no, Mr. Handik,
Lordship.
that we would not have entertained this. I mean, we would have surely differed with the London single judge. Contractual employment, they don't have a right.
Lordship.
That the contract is terminated. But here, your terms of contract is such that they are to be governed by the disciplinary rules.
That is true.
You reinstate them, follow the order, and then don't extend the contract. Mr. Roy Chaudhary will go to home.
Earlier, his contract was not been extended, not been renewed, Lordship. In our
It
order,
has not been renewed is something else. You
Lord.
do it now.
Lord.
The difficulty with us is you, because of your faulty wording in the contract terms, you create problems for the judiciary. And you want it to be straightened. He's a habitual defaulter.
Lordship, that is true.
So what do we do?
So we have, no, Lordship, we have
Actually,
given the warning to him, Lordship, several
As
times.
court martial, Mr. Handik. There has to be logic. There has to be a method even to madness, which I keep repeating. Kadiya, you show Mr. Roy Chaudhary the door, but then in a way which is commensurate with your contract terms. Dismissed. And give the appearance of Mr. P.K. Roy Chaudhary and. Yes.
Yes, Lord. Item 11,
Item number?
11.
Yes.
Lordship, I'm not asking for more than to remand because we didn't file the written statement before the CAT, Lordship. The matter is, Lordship, the respondent was appointed as a clerk in the year 1964. In 73, he passed.
Let notice be issued to the respondent on steps being taken. The only respondent, no?
Oh, so let's
Notice be issued to respondent on steps being taken by the petitioner / Union of India, petitioners / Union of India and others within a period of 2 weeks, both modes, returnable March.
deeply obliged.
18 March.
See, he opted for that administrative line. He opted for that administrative line and not the accounts line.
But taken all the benefit from as he retired as a senior postmaster and he is paying pension now, Lordship.
And what has the tribunal said?
To give him the benefit from 73 because he passed the accounts service exam. Also.
Proceedings against him during his tenure.
Lordship.
Multiple disciplinary proceedings.
Yes,
against
Lordship, two are pending before this court. The punishment part has not been interfered by the CAT, Lordship. Two writ petition, he challenged before this court, those are pending, Lordship.
All right, we'll see. He has to be here.
Item 12,
Please, your lordship. You have not here impugn order is in case number 72, my lord. Relevant portion is in case number.
Notice. Done. Nothing can be done, but even for hearing you, I think the other side has to be here. When was the judgment? Has he been reinstated?
My lord, those who are still working.
Has
there-
he been reinstated? There are many, 16 others. Have they been reinstated?
No, my lord, as those who are still working at that point of time, they were working.
Let
my lord.
notice be issued to respondents on a step being taken by the appellant unit, by the petitioner, Union of India and others. 2 weeks, both modes returning, so and so March.
16-3.
Yes.
Item 13,
Fishing in Kaziranga.
Your Lordship. Lordship, I seek apology. I was to file an affidavit, but due to some reasons we cannot file, but we have some otherwise.
There is some urgency in the matter.
Yes,
The
madam,
whole
we have.
The whole thing would be on 13th and 14th.
No, madam, we have instructions. These incidents didn't happen from last 2 years, madam. We have control everything. I have written instructions, madam.
You do one thing. You put it on affidavit. We have
Yes,
fixed it on Friday.
Lordship. Friday.
On the last, I mean, there were similar orders, prohibitory orders that were passed.
Let that be there.
Yes, madam.
See
On
how many
23
prohibitory
and
orders.
23 and
See,
25
it
didn't
has to
happen,
be,
madam.
Mr. Fukan, you would realize things have to be balanced.
Yes.
The ecology has to be maintained,
Absolutely.
but administration also has to take care of the religiosity, the religious sentiments of people.
Well, their own documents admit that there are commercial nets being used.
That you'll have to stop, Mr.
That is gone, that is gone. 2023 and 24, this
Put it
incident
on
not
affidavit.
happened.
We will not journey it after BU because BU thing in that during those period only you'll start fishing, commercial fishing and all that.
Page 44, their own
One or
document
two,
admits
somebody using a, what is it? Line.
No, my lord, it's not used. No,
line.
there might be one single instance sometimes, but it has been taken care of.
No, single instance, but commercial fishing.
No.
No.
Commercial fishing is not done.
If I can only show that document, my lord, page 44.
Suppose I carry my line. What is that called? What is that equipment called? Line,
Fishing
for
hook.
line caught fish.
No, my lord, these are indigenous communities which
I'm asking something else, Mr. Gogoi. Understand
Commercial
what
hook,
is asking. उसको क्या बोलते हैं जिसे मछली मारा था बंसी बोलते हैं हिंदी में. Suppose few, I mean, sporadic instances of people, taking line caught fish. That is not going to disturb the ecology.
Oh, I don't know. Yeah.
Bansi bolte हैं ना उसे.
Yes, my lord. Fishing hook.
Fishing hook is
Fishing rod, yes.
So if it is used by, say, hundreds of people also, it is not going to disturb the ecology. But if it is used on a commercial basis, then perhaps everything would be disturbed.
They acknowledge that, my lord.
Well, we'll come back on Friday. My lord. These are all.
Page
They
44.
I will
don't
comment, my lord.
acknowledge
They
it.
have
See,
anything, my lord.
once you have to tread on a tightrope.
My lord.
The government also has to say hundreds of people converge. If you don't allow them to have their, religious things done,
My lord, but there is no connect whatsoever, my lord, with respect. I am
connect is
submitting.
because you see it through the prism of rationality. Religious fervor does not go for rationality. They decide. Why do you believe in scriptures? We don't approve of it. But then the government has to tread very warily. We will not allow any commercial fishing.
It's not commercial.
Absolutely not.
Lord, because the rigors,
Can you stop people from bathing?
my lord, entering the sanctuary is my problem, my lord.
Entering,
They are not
That is-
entering. my lord.
that is a
They-
clear
everything is
violation.
conducted.
That is a clear violation of section
If
27
anything
and
happens,
29.
it's a peripheral area, my lord. And those communities, my lord, involved are those.
see, look at this. Kaziranga, which I only recently visited, it requires some protective measures.
Well, it's being protected.
Because 27 and
My
29.
lord, these communities, my lord, this
submission was
allegation
clearly
is,
violated.
which allegation is coming, my lord. These communities, my lord, which involved in, these are long before that, before Kaziranga was declared. These are tribal communities, my lords. They are involved in the ecosystem, and this is not they enter. They are not allowed to enter.
That argument we cannot take in black and white.
My lord.
This is contrary to
You-
their orders, my lord.
You,
prohibited orders.
as a state, you have to protect it.
Yes, we are protecting, my lord. If
We'll
something
see
happens,
what
also,
is
my lord, the peripheral area.
in
We'll look at
Africa.
it, my lord.
Let this matter come up for consideration on Friday.
9-1.
Obliged.
We are adjourning it for post Bihu for the reason of.
I understand, my lord. We will file, my lord. Obliged.
Obliged.
And please bring on record those prohibitory orders for those days, 13th, 14th, 15th.
My lord. Obliged.
Item 14 to 16.
Naga protection इसको बाद में सुनेंगे. This Naga protective regime, we'll hear it after Bihu.
Milord, Milord, even I was also trying, wanted to suggest that any date between 27 to 29 is a very contentious issue. Milord.
Yeah, I know.
And instead of having ones for admission, one for
Look,
final disposal.
Prima facie,
Yes.
the traditional view, what was part of Nagaland and what was not part of Nagaland would not be relevant.
Yes.
With the demarcation of the state, whatever comes in Nagaland goes inside the protective, sphere.
No.
This is against your thoughts. But then it has to be argued.
That's the tentative view of the bench, Milord.
No,
We'll try to persuade your lord.
No, this is not the tentative view. This could be the tentative view of anybody going through.
No, my lord, what we'll try to satisfy your lordship
Suppose
is
some part of a
by the norms and standards laid down by the state of Nagaland itself, we are good enough, my lord. Only thing is, my lord,
that's enough.
there is a gap between what is being preached and what is being done in the
And
ground.
who are you representing?
I'm in item number 14. Item number 14, I just give a brief gist. The same issue is going before the Honorable Supreme Court, Millet.
Same issue.
Same issue, Millet. By the state of Assam. So it's an original suit number 2 of 1988, wherein the state of
Anyway,
Assam
we'll
is
see it on the
yes,
No, well, that's a boundary dispute.
boundary dispute, but we are for
This
the
is a different issue altogether.
yes. We are
There is one overlapping.
Let us 1 second, let us hear from the Advocate General of Nagaland. Yes.
Lord, as far as the suit in the Supreme Court is pending, that is basically to demarcate the boundary.
This issue is not
That's
pertaining.
completely different. What they are trying to do is, they are trying to say that Dimapur was once a part of some other district.
Let me understand.
And they have admitted in the first petition that
No, Mr. Balgopal, I have asked you to respond to his argument that the matter is pending before Supreme Court.
No, that's separate. Nothing to do with it.
We are on
And I also want to point out one thing for your lordship's kind consideration. This is not a PIL. This is a great game which is going on. In 2019, the same issue was there before the Supreme Court. And
You have the judgment order?
Where's that order? The same issue was there before the Supreme Court, and the matter came up before the then Chief Justice of India, who incidentally had a good idea about this being from the same from our state. And then what happened was the matter was heard and it was dismissed. And I'm just passing that order. They'll just keep on saying each time something or the other.
I'm so
Yes,
sorry.
so kindly give
The
it.
notification that we are challenging is of 2024. How can a 2018 order govern us?
Just, you
The
don't,
notification is 24.
just, you don't worry about that.
We would also like, this is by Ashwini Kumar Upadhyay,
Yes,
the
and he's the
the
counsel,
advocate from UP.
and he's the counsel in the petition of Karen Pero. He's aware of that, that his first petition is dismissed.
Anyway, we'll hear it after view.
Yes.
Let's the 20. I'll just give a brief just. 20. We are on something extremely. What is not before, my lords? This 24 is
All
the
right, so if the
notification.
matter is pending before Supreme Court, we shall not hear your matter.
No, Milits, I'm not on that. The 24 notification that is before my laws that we are challenging today.
That's okay.
What has happened is Milits, there are two notifications. One is of 76. The other one is 24. The 24 Milits oust everybody who was recognized in 76. And Milits, the powers of the governor is being taken away by the Milits, the chief secretary. So without all of these rigors and approvals, the 24 has been passed and is operating against us.
My lord, this
So
petition,
even people who were recognized in the earlier notification have been ousted today. Now
Well,
2019.
All right, we will hear you, we'll give you
My lord, I
proper
think,
allot, I mean, we'll allot
Yes,
time
yes.
to you.
So
to
it's a
answer.
separate issue is what I'm trying to say.
It's all right.
Yes.
All right. For the present, we are not detagging it.
My lord.
It shall remain
together, yes, yes.
We will hear it on that day. If your case is totally different, we will segregate.
I have one suggestion to make. to the
Yes.
Lord Supreme Court. The first and second matter primary relates to item 15 and 16, my lord. That is specific to inner line permit.
Yes,
That is one matter.
yes.
What item 14, which my learned friend has been talking about,
Huh.
we received the PDF copy only on 3rd of January this year. So naturally, they will file counter. And that has got nothing to do with the ILP.
Okay,
That is separate. That can be heard.
okay, okay.
That's
I
a,
can show
That
two
is a-
pages and convince
We-
Lordship as to.
that's
We-
a separate
we-
issue.
Today, we will put it on a different day, 15 and 16 on a different day.
15 and 16 on it.
Yes, Lord, it can be put differently.
Differently because the issues are
14
different.
Maliko,
We are the
Mr.
people
Balgopal.
ousted.
Learned Advocate General for the state of Nagaland, submits that by the next date, the response affidavit shall be filed with a copy in advance, with a copy served in advance to the council for the petitioner. Let this matter be listed separately from item number 50, and let this matter be listed on. We keep it in February. Is that okay, Mr.
Towards the end of February. Readings will be complete by then. We'll file our counter. They can
Which
file their
date
return
are you suggesting?
towards the end of February, subject to your
Ah,
lordship's kind
February.
guidelines.
Milord, can I just come in, Milord?
We'll be
On the
passing-
date, Milord.
Hmm?
Now it has so happened, Milord, so because of the insistence on the inner line permit, we can't even take our children to the school. That's the urgency, Milord. That's why I was
Complete bogus.
suggesting,
No, for you, you
Bogus.
have an earlier date.
Milord, why my learned friend is using all these
Yeah, then
expressions,
what,
bogus.
Then why do you make false statements to the court? We are completely liberal in ensuring that everybody can come and be made very limited.
My learned friend
restrictions.
doesn't have the
We
license
had
to
a
say,
cabinet
make any
meeting,
such
and in the
submission.
cabinet meeting, everything
Let
was
them-
tracked down.
We decided
We have
together, Your
given,
Lordship.
we have liberalized everything.
We decided together, Your Lordship.
Milord, let us
And
not
they are
make it.
playing freedom of movement without any restriction.
I think my learned friend will mind his language.
You
Milord.
should also.
We are in a
mind-
court of law.
You should mind your language when you speak false statements.
Mr. Balgopal, what time in January after Bihu would it be all right?
Milord, I was praying for any date between 27th and 29th.
That's what I'm asking.
Yes.
Both the matters.
My lord. You can tentatively keep it. Can I just check up in a minute, my lord? I will
Yes,
inform the court
yes.
master. This date can be placed. If there's any change, I will.
Yes. So item number 15 of the thing?
14 and 15.
No. 14 we have,
That's separate.
Plus the
That's
notice
separate.
is
So,
not
Your Lordship,
issued in
it's
that matter.
better to hear both the matters together because the issues are flowing.
More or less,
no, issues are different.
all right, so the judgment in one would govern the judgment in
Yes,
other.
Your Lordship.
Please don't worry.
So let it.
One day, all of you advocates together, it will be
Let
difficult.
it
to
be
contain
together, Your
policy.
Lordship. Better, Your Lordship. Let it will be better for Your Lordship also.
If you leave it to us. All right. So this comes in February end. because of the urgency shown by Mr. Chaudhary, we would be keeping 15 and 16 sometimes in January, last January.
Yes.
Correct? Mr. Balgopal,
That's
no
right.
difficulty?
Right.
But we will require your presence in a line problem. Huh?
I was just reading our.
By January end, I think Guwahati would be a better place to visit.
Very well.
Because Delhi would otherwise be very cold. This would,
I was just going through the cabinet decision for bringing the children, no ILP is required.
For bringing the children, no ILP?
No, it's here. I filed it. They just.
You will file that. All right. So, but January end, we keep it?
We'll keep it.
Item number 15 and 16. Let both the matters come up for consideration on. Give a date.
27th or 28th, my lord.
Maybe 28th or 29th. Let the date be fixed. If there's any
Date
correction,
open run.
I'll inform the court.
Please ask your counsel, your Anatoly.
Yes, yes.
And you are? Please let the court master know the date. All right, 28th or 29th.
Yes,
Mr. Balgopal, but you must be here. If you're not physically here, you appear virtually.
Yeah, I'll be there. That's why we came. We wanted to appear.
All right.
Item 14, Notice is not issued, so Manoj may consider issuing notice in item 14.
15 and 16 is, we have fixed it. 14 is on that date. Don't insist for anything else.
Yes, the notice is not issued in 14. So
Doesn't matter.
Doesn't matter. At least, because
Doesn't matter. Unless we hear, we will not issue. Yes.
Lordship, 16, your lordship, the pleadings may be completed. Reply is yet to be filed on the in item 16.
because I have traveled all the way from Delhi. If my lords may consider hearing it today and issuing notice or not.
You're not the only person coming from Delhi.
I agree.
Please don't make such statements.
I'm so sorry.
No. Young person, see, he comes from Delhi.
Well,
has he made that statement? So we'll hear you on that date. If notice is required, you will come again. That's a good place to come. All right, yes.
Complaint. Yeah.
14.
Chalo, next.
Yes. 25th February, 14.
They've not issued.
25th.
Item 14 date is decided.
Item 17.
My lord,
Why have you come here, sir?
my lord, only on the, I am in fact, if your lordship sees my prayer, only on the substantial question of law.
To tell you a fact, don't take it otherwise.
Not at all, Your Lord.
This is a wrong forum.
I understand, your lordship. Under 18,
And in such cases, I am inclined to impose cost.
Lord, if
You know the law. The way you have drafted your petition, it appears that it has crossed through very expert hand. But look at the misadventure.
my lord, I'll just take a minute of your lordship.
Not a minute. You take a minute and you pay 1 lakh rupee cost. What is this?
Very well, your lordship. I was only on the question of law, nothing other. In fact,
Question of law, tell me. This is without fear of any cost being imposed, but 1 minute only.
very well.
Yes.
Lordship, under section 14, the powers are specifically
Who
concerned.
doesn't know?
Yes.
Do you require an exposition of law on that?
While passing the order.
Question is this. Now, the order was passed, it was not passed, no effort was made, whatever. Some order was passed in favor of the loanee.
Yes.
So that order could be questioned. The order has been passed by DRT. Now, why have we established the appellate body, DRAT? Can it not be questioned? And you don't need an exposition by a division bench of Guwahati High Court comprising Chief Justice and another judge, where the matter has been decided by Supreme Court in large number of cases.
I went through the judgment of the Supreme Court, Lordship, specifically on the issue of whether the subdivisional magistrate.
Specific judgments by Justice M.R. Shah and many other judges. I don't remember. My memory is short. I don't remember the names of the cases, but the issues have crossed my eyes. So many. And in fact, the statute, the section 14, the recital of section 14 is absolutely clear. You don't need a further exposition on that. You now anything beyond.
May I make this one prayer, Your Lordship? Since we have already
Withdraw to approach the DRE.
that liberty may be granted because 30-day period has already passed, Your Lord.
That we don't know. You have wasted.
Lordship, may kindly at least because I was here only on the question of law.
How do we tell the appellate court that please condone the delay?
Only that liberty may be granted, Your Lordship.
Again, after some arguments, Mr.
KP Pathak, Your Lordship.
Mr. Pathak,
Yes.
advocate seeks full name.
Kaustav Prakash Pathak.
Mr. KP Pathak, learned advocate, seeks permission to withdraw this petition in order to agitate his claim before the appropriate forum, that is DRAT. Dismissed is withdrawn with the liberty of person.
Deeply obliged.
Item 19.
Well played, Your Lordship.
Yes, sir. This is that
Assisted reproductive.
assisted reproductive. We will hear it on some other. You have challenged 21G as unconstitutional. Huh?
Yes, Your Lordship. Only
There
on the
is
issue.
no judgment already.
Yes, Your Lordship has given a judgment, but on that judgment I have gone through, Your Lordship has not considered the aspect of the silence with regard to commissioning couple.
Yours is not the case of commissioning couple.
Yes, mine is a case of.
No, it failed. Commissioning means the process is midway.
No. Commissioning couple is the married couple who is intending to take the treatment. It has been defined under the Act.
That was the issue which was decided by my brother.
Yes, Your Lordship, there.
Lordship,
I have the copy.
Then let's see.
Already decided. Section 21 was challenged in this petition and this petition also.
Yes, it has been challenged, Your Lordship.
Section 21G.
The option before you is Supreme Court now.
No, but Your Lordship may just
This
note.
has been decided in accordance with our wisdom. You're not satisfied, you go.
No, Your Lordship may just, my aspect is here.
Well, we'll hear you on some other day.
Did.
Oh, the chali ka, right? Anyway, ये judgment के साथ देता.
Yes.
Keep it in the file, we'll hear you on some other.
Not so.
Yeah. But nothing is left to be decided now. It's an age-based legislation. After so
Your Lordship,
many-
what has happened in my case, the wife was waiting time.
Wife is less than 50, husband has crossed 56.
But the Act does not prescribe an age for the commissioning couple. The age of the husband and the age of a man and the age of a woman is treated as a separate unit. And my submission, with all due respect, is that that age cannot be utilized for the purpose of a commissioning couple.
This aspect we may not have dealt with, but then we'll deal with it
that's
again. Anyway,
Next. Your Lordship, in February or?
No, March. Let this matter come up for consideration on so date March.
9th March. 9-3. Item 20.
Which army do you lead, Mr. Senapati?
No one, Your Lordship. I don't have that.
No
privilege.
army.
No.
All right.
Please.
Yes.
They have filed reply to
Item number?
21.
Item number?
Item number 20.
Yes.
No, they have filed their reply today, my lord.
Lordship, today we have filed an affidavit. That is not on record, Lordship. However, I have extra copy that the Lordship like to peruse.
Affidavit filed by the state is not on record. Let this matter come up for consideration on immediately after reopening. Is about completion of the road.
That is likely to be completed by 10th of March 2020.
Let's see. Let's
That
see.
we have stated, Lordship.
And there was some complaint that you started from the end point and not the starting point or something. Something like that he has argued.
Lordship, that we have already incorporated in our affidavit.
All right.
Lordship.
20th January.
Give a
20.
to him. Yeah.
Lordship, copy has
We have gotten.
21.
obliged.
Item 22.
My lord, this is Somoto, my lord, is regarding, my lord, the which encroachment of the government land by the government department. Department allotted to the defined department, my lord, and they were asked to file an affidavit. They have filed an affidavit, but my lord, affidavit
is not satisfactory.
My lord, I'm not going to open my mouth, my lord. Let him.
Lordship, may I plead, your lordship? Lordship, in this affidavit is not very clear, your lordship. There has been further developments.
Very fair on your part, Madam Counsel. What's your name?
Nivedita Bordolin.
Very fair.
Lordship.
Now you want to file another affidavit? We are agreeable to it.
My lord.
Yes, your lordship, I'll be very obliged.
MS so MS Nivedita, पूरा नाम क्या सुना? Mrs. MSN, Miss M.N. Bordoloi, Learned Standing Counsel, Revenue, very fairly submits that the affidavit filed by her earlier is not very clear. So she seeks an indulgence of the court. She seeks a permission of the court to file another affidavit explaining the issue. Permission is granted. Let a fresh affidavit be filed on behalf of the state by the next state.
So
Re-notify. We keep it in March.
I'm so obliged.
12 March. Item 25.
Mr. Nayak, you visited that place?
Yes, Lordship. In fact, today morning also I
We
was
in fact
that.
said that
Lordship,
Mr.
one,
Nayak will.
one affidavit, Lordship, I would like to refer, Lordship, that is filed on 18/12/2025 by the PWD fund. I'm only praying your Lordship to go through the photograph. 18/12, that's.
Where is Ms. Ghosh?
Your Lordship, she's legs in court number 16. Your
Ms. Ghosh has to be satisfied. She was very passionate about the.
Yes, Your Lordship. In fact, we have filed one affidavit in reply to the affidavit that is being referred by my friend.
Lordship will see the photographs only, Lordship. This is the condition of the road.
Photograph is where?
Page 102. It starts from page 102.
Well, it will close it then. But then she has to be here.
Yes, Your Lordship. Let the legal counsel be here.
नहीं है यहाँ.
Page 102.
102, yes.
In the affidavit filed on 18/12/2020.
Absolutely fine shape. This is the near Cotton University.
These are the photographs.
Near Cotton.
Colored
University.
photograph. It starts from page 102.
Next page there. I think she would not insist further. And you have personally visited.
Yes, Lordship. Even today morning also I was told that.
Your Lordship, let the legal counsel be heard in this matter because she has filed one affidavit yesterday.
Legally. Wait. Let her come. That is
Yes,
what we are.
yes, yes.
Yeah. The matter is adjourned for today to enable MS Ghosh, Learned Legal Aid Counsel, to appear in the matter.
Yes.
So far as the condition of the road in question is concerned, Mr. Nayak has pointed out that it has been repaired and nothing more is required to be done. He has also visited the site personally and has submitted that now the petitioner and now the concern of the petitioner has been effectively redressed. Re-notify on something here. After view, we'll close it.
30th January. For hearing, item 26.
May it please your lordship, Miss Luthra is on her legs in another court. Is it possible to pass over the matter?
No passover, but Mr. Datta file an affidavit.
My lord, an affidavit has been filed.
We have received the copy on 5th of January of the additional affidavit.
We keep it after view. Would that date be suitable to MS Luthra?
Sure.
What happened, Mr. Datta? Suffering from cold under the weather.
Yes, my lord.
You filed the affidavit.
Yes, that has been filed.
I think we can close this. The offer of the what was offered by ESIC is more than fair.
My lord,
Much more than fair.
my lord, this thing that has been disclosed in the affidavit. is
Anyway, we will. You're still to argue. Nothing shall be recovered from those persons who have retired.
Barring
Others also, they say that they will stop making extra payments, but then nothing would be recovered. What else do you want? You want entire money to be given to you, taking it from others. He's in a, Madam Council, Mr. Datta is not in a good shape. So we will adjourn it for another day.
Any date after Bihu, my lord, as she is also.
Your lordship may reserve for orders after next date.
How we can do that?
On 19th.
For delivery of judgment.
On 19th.
Anyway, on 19th we will hear, we declare judgment only in the court. Therefore, don't worry about that.
Great.
And the only thing is that, my lord, the record affidavit.
It will come at the request. Not 19th. We'll not keep it on 19th. First day. You would not recover from overeating. Let this matter come up for consideration for final determination on 20th of that. What is the hearing day here?
20th and 22nd.
On 20th of January.
Obliged.
Obliged.
I think we are closing. Most of the arguments I have dictated in my order.
This is already recorded.
Timing matter 30.
Lordship's, the IA is still on its way. It has not yet.
We'll hear you after when the court reopens.
Lordship, the IA was for stay of the impugned order.
Delay first, it has to be condoned. Delay has to be condoned. Who is your senior? Somebody, some elderly person was here.
Yes, Mr. Espiro is missing.
Delay we can condone. What?
Lordship would like to file an objection for the.
You would like to file an objection. File your objection by the next date.
Lordship.
19th. Let this matter come up for consideration on. There's an application seeking condonation of delay of so many days. So many mat likh dena. You write of so many days in preferring the appeal. Mr. So-and-so, learned advocate, has appeared for response number.
Lordship, for all the responses, APDC Act.
Response number so-and-so. He submits that he shall be filing an objection petition by the next date. Re-notify on so-and-so day. Immediately after view. ये वो PIL में रख देना. That Nagaland. Yes.
Deeply
6th of February. Yes, list open.
Deeply obliged.
Deeply obliged.
Good.